This lesson is on your individual rough drafts, really at this point, focusing on your individual role in the trial. Okay, and so once you have your charges and you have the list of witnesses for the prosecution, the list of witnesses for the defense, then we need to focus in on you writing out a rough draft for your role. There are multiple roles for the lawyers, so depending on if there are 3 or 4 of you, you're going to divide them up. So one of you will have an opening statement, and these are meant to give each side some details about what the jury will be hearing. You just like highlight the main points, foreshadow for the jury the coming trial, and you want to create a favorable impression. It's an opportunity to introduce your case and explain your side, why you think the defendant is guilty or why you think the defendant is not guilty, and then a summary of the case, which should include the charges and the arguments why they're guilty or not guilty, and a list of witnesses and what their testimony will show. So there is a rough draft form if you choose to do this one. And this will be assigned to you in Google Classroom, so you can type in it and print it. In the end, we'll be printing 3 copies. One for you to take with you, to take home with you to practice, one for the folder, and one for us in the courtroom, in case you forget yours or need to refer to it. So you'll print 3 copies. So you would fill this out, right? It just kind of walks you through what you are going to do. If there aren't 3 charges, you just ignore it. So if there's only 1 charge, you just have to do that one, 2, or charge 3. All right. Then kind of the next part is direct examination of your side's witnesses. So that's you calling your witnesses. And they can only testify by answering questions, so you need to ask the questions. This won't actually be difficult because the rough draft for the witnesses includes like a question in front of where they're going to type their answer. So as a lawyer, all you really have to do is ask those questions. A good direct examination will ask 7 to 10 questions, and see the witness testimony below to help you develop good questions. So you're just going to be asking those questions to the witness. And we can go over that a little bit more with the witness statements. You're going to divide this up, okay? So if there are 4 of you, one person will take the majority of the direct examination, or you'd split up the direct examination between you and a cross-examination. And so maybe each of you kind of do a piece of it. So you would like divide it up. The person who's doing the opening statement and the person who's doing the closing statement, they should still at least do 1 or 2 direct examinations, but the majority would go to the 3rd or the 3rd and 4th person who is the lawyer, okay? So then you also have cross-examination, which is the goal is to raise doubts about the other side's witnesses' testimony. You want to try and find the holes in the story or bring out what they did not see, kind of discredit the testimony because maybe of lighting or distance, angles, something like that, or maybe a motive to testify, such as they're getting a reward for it, or they're a family member, or on the other side, maybe they want revenge against the defendant or biased against the defendant. Typically, a cross-examination will consist of 3 to 5 questions. So again, if there are 4 of you as a lawyer, you kind of split up, and 2 of you would do half the direct examination and half the cross-examination. So you're doing both pieces of it. And so there is a rough draft for this as well. And again, this would be assigned to you in Google Classroom. And so it's where you put your name and whether or not you're the attorney for the prosecution or the defense, the name of the witness, because this would be the other side's witness, not your witness. So what's that witness name? What do you think they're going to testify to? So is it a murder charge or an arson charge? And what do you think they might say? And so then a strategy. How could you discredit or cast doubt? You want to cast doubt on that witness's testimony, right? You don't have to totally prove that they were wrong, but you want to make the jury think that maybe they're not 100% certain and they could be wrong. Remember, you just need reasonable doubt. And so you fill this in for the number of witnesses that you might cross-examine. Again, it's kind of split up the list between the two lawyers doing direct and cross-examination. So you each doing half. And then the closing statement. So one of you will do the closing statement, and that's the last thing the jury will hear. You're going to wrap up your case. You're going to summarize the testimony that was heard, right? You want to bring out certain testimony that you think is particularly persuasive and favorable to your side by summarizing what was presented. You can include cross-examination. So if you had a particularly successful cross-examination, you might want to point out that, that witness can't be relied upon. And then you explain that the evidence means the jury must find in your favor based on the facts and the law. And again, there's a rough draft template for you. And this is how you would fill out your closing statement rough draft. And again, depends on how many charges there are. If there's 1, 2, or 3 charges, or is there just one charge, then you just have to do it for the one charge. But you still kind of have to include all the witnesses. So you will have to get together. You're going to need copies of the witness's testimony so that you can include the highlights of it, right? Like the basic thing that witness, you don't have to include all the details, but like the basic picture that the witness is testifying to. So we're here to help you with that as well. Okay, and then this is an example of what the witnesses are going to be filling out. And you can see all the questions here. So this would be for direct examination, and you would simply really need to know these questions, right? And so you would be asking these questions, hopefully in order. If there's physical evidence, you would need to ask these questions of the witness. And when you're done, you say no further questions, Your Honor. Okay, so if your witness gets stuck, right? So they're kind of forgetting their testimony or not saying everything that you thought they would say, right? You can ask them follow-up questions. I have some examples down here. So if you don't feel like they're given enough detail, you can ask them, well, what time of day was that? Or do you remember the date? Was it this date? If they don't remember, you can prompt them with the date yourself. How far away were they? Did they have a clear view? Could you hear what was said? I'm not really sure why that's there. I think that's supposed to be a question mark. There we go. And so you can ask these kinds of follow-up questions of your witness if they get stuck, okay? So you are really going to have to know what your witnesses are testifying to. Okay, let's talk just a little bit about physical evidence. So you have to have 3 exhibits entered into the trial, which are physical pieces of evidence that you can submit. Think of it as, evidence, clues, right? And so in order to do that, you're going to have the witnesses do it, which means that you as lawyers are going to have to introduce the evidence at the court, right? So what you typically do is you go, Your Honor, we'd like to submit Exhibit 1 or Exhibit A to the court, right? And so in order to do that, before you can actually have it submitted, you have to ask some questions. So you would pick the evidence up, and you're going to need to ask the witness questions so that we know where the evidence was found and by whom, who does it belong to, and what is its importance. All right, so ways to do that, right? You can ask the following kinds of questions. Have you seen this before? When or where, depending on what it is. You could ask both questions, one or the other. Please tell us what it is. Please tell us to whom it belongs, right? So if it's a map, or it's coins in a pouch, or it's, some type of piece of clothing that was torn, right? That would be somehow recognizable. Maybe it has a symbol on it or something, right? The witness can testify, oh yes, and it was found at the scene, right? So you ask the questions, the witness answers these questions, okay? If it's something that's written, a document of some kind, you can ask the witness to read the evidence. So if it's a letter, for example, you can ask them to read it, and then it would be read into evidence for the jury so the jury can hear it, okay? So it just depends on the kind of evidence that it is.